Would you ever sign a lease agreement with an eggplant emoji? You might. And then the question would be, is it valid? I'm Shaunik, rhymes with Sonic. I've been a plaintiff's litigator for almost 10 years. That means I represent people, usually against big corporations or government entities. And I love the law, and I love using it to help people every day. Today I'm going to talk about emojis as signatures to contracts. And it's kind of a wild area of law because, yeah, emojis can be valid signatures. I'm going to talk about that. I'm going to talk about the history of symbols or marks as valid signatures, because this goes back in time. And then I'm going to talk about some of the issues, mainly who the heck knows what an emoji means? Everybody has a different idea, and that can be a real problem when it comes to determining whether somebody actually agreed to the contract. People use electronic signatures all the time. DocuSign, Adobe Sign, whatever it is, you get a lease, you get another kind of contract pushed to your phone, pushed to your email, and you either use your finger to draw out your signature or you use your mouse to draw it out, and boom, you've got a contract. That's because both federal and state laws allow for electronic signatures to be as valid as handwritten signatures. Some laws impose additional requirements that are specific to electronic signatures, like an authentication requirement. So, when you sign a DocuSign document, there's that string of letters and numbers next to your signature, and then an audit trail, a couple of pages at the end of the signed document that list out sort of how that document got signed and where it went, sort of a chain of custody showing that the person who signed it was the person who received it. Some of the laws also may require some notifications in the contract itself that say, hey, you're allowed to receive copies of this in paper if you want. Other laws just say, we're going to treat electronic signatures as if they were handwritten signatures, and basically adopt all of the law around handwritten signatures and just say, electronic signatures, same law applies. But you know that if you've ever agreed to anything on your phone or your computer, that agreeing to something or signing a contract is not always signing a contract. When you agree to a terms of service on an app or a service and you click the box or you click I agree, that's called a click wrap agreement. It's called click wrap because it comes from an older term called shrink wrap agreements. And shrink wrap agreements were way back when software used to come in physical packages. The manufacturers used to shrink wrap the cellophane, plastic covering onto the packaging and actually print the license agreement on that cellophane, plastic wrapping. And so it would say, if you tear through this, you've agreed and read and accepted the terms and conditions. That's click wrap now. By clicking next, by clicking I agree, by swiping, you have assented to the terms of that agreement and represented that you have read them all and understood them all. Backing up for a second, in order for a person to validly agree to a contract, it generally requires that that person has indicated in some way, unambiguously, that they assent, that they agree to be bound by the contract. So based on a history of common law, signing your name means I agree to an agreement. But what about clicking? In the last couple decades, a robust body of case law has determined that, generally speaking, clicking that checkbox, clicking I agree, is the same as signing your name. It is an indication, an unambiguous indication, that you have assented to the terms of that agreement, that you have read and understood it. But anybody who's actually had a 40-page terms of service show up on their phone and had to click I agree knows that clicking that checkbox doesn't actually mean I've read everything. Still, courts have said, look, if you scroll through the thing and then click I agree, you're presumed to have read it. You at least had the opportunity and you made the choice not to do it, but you signed it, you agreed to it nonetheless. It's a little bit of a different calculus when there isn't something to scroll through, and that's where there's been some dispute among states and federal courts about what is the right approach here. If you get a screen that says, I agree, and by clicking this checkbox, I am representing, I have read and I understood the terms and conditions, but the terms and conditions aren't actually on that page. They're linked, or you have to go somewhere else to find them. Well, there's been a dispute about how to treat those. Generally speaking, if that hyperlink to the terms and conditions is there and it's unambiguously, visible and present and called out, courts have been more inclined to say, yeah, you agreed to it. You had the same kind of opportunity as you would have if it was, scrollable there. That's different than if the checkbox points you somewhere that you have to go find yourself. They don't hyperlink it. It's difficult to find. Well, then courts might say, you didn't really have enough notice of what the terms and conditions were. You couldn't reasonably have found it. They didn't call it out enough for you. They were hiding it. So there is some wiggle room, some gray area in how these click-wrap agreements are treated, but it generally has to do with the fact-specific circumstances of, did you get enough notice of what those terms and conditions were? Did you have an opportunity to read it? Not so much did you actually read and understand it, because a lot of that is presumed if you've had that opportunity. But did you have the opportunity, and did you click it anyway? Because agreement to a contract often turns on intent, we're trying to divine the intent of the person who signed it to determine whether the mark that they put is something that says, I agree to this contract. We know that signatures of a name are that. We know that whether it's electronic or whether it's handwritten, signing your name does mean I agree. But what about other symbols? Because symbols can be valid assents, can be valid signatures. And that's why some courts have found that the thumbs up emoji, for example, is an agreement to a contract, just as valid as signing your name on a document, either electronically or manually. Putting a thumbs up emoji is, I agree to this contract. That's what some courts have found. Symbols as a form of agreement to a contract are not a new concept, especially because literacy, to the extent that it exists now, is such a new concept. For most of human history, most people did not know how to read or write. And yet contracts, agreements have existed for a large portion of that time. So things like wax seals and other stamps have long been held to be valid agreements to contracts. Remote signatures, signing something from far away, even if you're not in the same room as the document itself or the other party, that's not a new concept either. And in fact, the electronic signature laws that we have now are really based on laws from the 1800s that came about when telegraphs and Morse code was in common use and became a way for people to agree to things, to sign contracts over long distances. Courts back then found that it doesn't matter whether the signer of an agreement is signing with a normal pen or a pen made of copper wire 1,000 miles long. What matters is, was there an intent to agree to that agreement? And did the signer take some affirmative step and leave an affirmative mark on the document that evinced that intent, that showed that that was exactly what that person wanted to do? So just a quick recap, what do we know? Electronic signatures are as valid as handwritten signatures. You can sign something with a symbol or a mark just as you could sign it with your name. And the crux of all of those things is that the thing you do, whether it's tapping or clicking or writing, has to show unambiguously that you intended to agree to the terms of that thing. Well, that last part is kind of difficult with emojis because, first of all, emojis mean different things to different people, to different generations. And so even something as innocuous as a thumbs up emoji can have very different meanings depending on who is sending and receiving that emoji. Older folks, millennials included, use a thumbs up in a more traditional way, yes. But that's not always how Gen Z or younger use it, if they use it at all. It may be more sarcastic or ironic. It may not always mean the same thing, especially when you have a disconnect between the person agreeing and the person who is on the receiving end of that. And that gets even more complicated with all the different kinds of emojis that there are out there. What does the okay emoji mean? Does it mean yes, or does it mean a whole host of other things that have nothing to do with agreeing to something that's presented? What does a smiling face mean? Which kind of smiling face? Because there are like 30. These are all complicated issues of ambiguity when it comes to the intent of somebody using an emoji. And again, it very much depends on the context. Usually when you look at the validity of a contract, you're looking at the four corners of the agreement. You're looking at what is on that paper or document. And you're not looking outside of it because that document is supposed to encompass everything that exists about the terms of that agreement between those two people, unless there's ambiguity. If there's ambiguity, then courts will sometimes be allowed to look outside of the contract. They can look at what's called extrinsic evidence. They can look at communications between the parties leading up to the signing. They can look at notes that may have been kept, prior agreements, to get a better picture of what the intent was involved in the signing of that agreement or agreeing to those terms. That in itself can create ambiguity, especially if the person receiving the emoji, the message, is visually impaired or elderly, and they're receiving it through a screen reader, like VoiceOver, which is reading it out loud. There are so many smiling face emojis. If somebody wants to assent to an agreement and they are intending to say, yes, I agree, and they send that one emoji that looks like that person going to say, yeah, I agree, the person receiving it will have a screen reader that's reading it out to them, and they will read it out as what that emoji is coded as, which is the smirking face emoji. And I don't know if I hear that, whether a smirking face means I agree, and they may not know either. And so that's another area where you can actually have a lot of miscommunication between what is intended and what is received simply because emojis are complex, symbols are complex. Generally speaking, symbols are more difficult to ascertain meaning from than writing. It's why we have writing. It's a little more objective. It's a little clearer. It doesn't convey as much. And that becomes a problem when you're using it to agree to a contract. By the way, you may be sitting here listening to me and thinking, I would never use a thumbs up emoji to agree to a binding contract. Are you so sure about that? What if somebody is talking with you over text about selling a pair of shoes or a pair of headphones, and you're negotiating, and they say, okay, fine, I'll do it for $50, and you've had a long string of conversations, and that's a deal, and you send them a thumbs up. That's a contract. That is a valid, enforceable, written contract that you have agreed to. It's a contract of sale, and you have agreed to it with a thumbs up emoji. So there are a lot of contexts, there are a lot of times when you may actually enter into a contract or a promise and use an emoji, even if it doesn't seem like a lease agreement or a terms of service. These contracts that we have and we make with people in everyday life, they can be binding and enforceable just like a lease agreement, and you will potentially use emojis in doing them. Now, these kind of contract issues, especially with electronic signatures, come up a ton when we're talking about arbitration agreements. They're a special kind of contract. You've signed one, I'm sure, in any kind of terms of service you have. And it basically says any dispute you have that arises out of this contract or between the parties has to be resolved not in court, but in binding private arbitration, which is a different kind of forum. It's not a public court forum. And then you're sort of stuck in this different area to resolve your dispute, and you don't have access to a jury and some of the protections that you might have in court. You have some other benefits in terms of the speediness and the informality of it all, but it's a trade-off and you're giving something away. People often sign arbitration agreements without really realizing what they are doing, and they do it through click-wrap agreements, through checkbox agreements. And so if you want to hear more about that, because it's a fascinating body of law and it really does impact everybody on a daily basis, check out this video, which I did about a forced arbitration agreement and a wrongful death case at Disney. Otherwise, thanks for sticking around, and I'll see you next time.